know that everybody remembers what I say about it. So I'm hoping that Nikki can send this PowerPoint out to everybody once we're done. I'm not going to just read every screen, but I want you to have it all as a resource. I'm going to be talking about Marsy's Law in general. I'll focus a bit on domestic violence, sexual violence, and stalking because that's what we do. But it does apply to other cases, and I'll talk more about this. And then please note the disclaimer. All right, so just some background on Marsy's Law. It's a little bit controversial. Marsy's Law was a campaign that was spearheaded by this Henry Nichols III. His sister was murdered in California and by an ex-boyfriend. And he felt that his family wasn't notified about what was going on and things were happening without he and his family being informed about it. And since he is some sort of billionaire, he then decided to dedicate his time to Marsy's Law, named after his sister, so that other people don't go through the same thing that he did. So he has been working across the country to get constitutional amendments passed state by state. This constitutional amendment was passed by a ballot referendum in November of 2014. There are some states in which Marsy's Law passed, and then they have since repealed it because it is burdensome and it is a difficult thing to deal with when it's a constitutional amendment. What I will say, and that's really important to understand, is the state of Illinois was really smart. When the constitutional amendment passed, the state of Illinois understood that that wasn't enough. So they actually codified Marsy's Law. So it's in our statute. So advocates and prosecutors met. They revised the Rights of Crime Victims and Witnesses Act to implement the rights that were guaranteed by the constitutional amendment. So in Illinois, it's a little bit easier because we have the statute which explains what we're supposed to do. And then this law went into effect in August of 2015. There have been some changes to it made recently, but a lot of what is in this PowerPoint, I'm hopeful that you can just have as a resource if you need to look something up. So the other thing, just as an interesting note about Henry Nichols III, is that he not too long ago was arrested and charged federally with drug trafficking, which I just think is kind of interesting. So there are many constitutional and statutory rights that are guaranteed to victims of crime from not only the constitutional amendment, but in the statute. So these next couple of slides just go through that so that you can have that. I'll be talking about them more in person, but I think that the first one listed here, the right to be treated with fairness and respect for their dignity and privacy, and to be free from harassment, intimidation, and abuse throughout the criminal justice process, is really the main reason that we have Marsy's Law and the Crime Victims Bill of Rights in the first place. It also guarantees rights to notice and a hearing before a court ruling on any request for the victim's records, information, or communications. I'll be talking more about that later because the law has recently changed to put some extra burden on the prosecutor's office and to take away some of the burden on the defense attorneys in trying to get privileged information. There also is the right to timely notification of all court proceedings. And as I think a lot of us know, with the upcoming Pretrial Fairness Act, there are notification requirements under the Pretrial Fairness Act, and by statute and by reference, they reference the Crime Victim Rights Act. So I'll talk a little bit more about that too. They have a right to communicate, a right to be heard after arraignment at any court proceeding, the right to be notified. So I'm not going to just read all of these out to you. So one of the things that's interesting and can be difficult with Marsy's Law is to figure out who the crime victim is. There are multiple prongs depending on the age and competency of the person, whether it's a murder case or something where the victim is deceased, or whether the victim had a role in the offense, that makes it difficult sometimes to determine who the victim is. A victim can also choose to have somebody be their representative. So that doesn't mean an attorney, but they can say, well, I want my sister to be my representative. So do all the communications with my sister. My sister's going to be the one in court. And they do have a right to have a representative to do that. So under the statute, persons 18 years of age or older who suffer a direct physical or psychological harm as a result of a violent crime, which I will talk to in a moment about what the definition of that is, or an attempt. So the victim can also choose an immediate family member to be designated as a victim. So then there would be two victims. So if I were a victim of direct physical or psychological harm as a result of a violent crime, so domestic battery, I can choose my mom or my daughter to also be designated as a victim, even though they did not suffer any harm. But then there's two victims, so both victims can be asserting their rights. Now, a person under 18 or an adult who is incompetent or incapacitated, so maybe think if somebody has guardianship over that adult because they have an intellectual or developmental disability, or maybe they're incapacitated and they're in a coma or in a medical situation that they cannot respond to anything, then the minor would be a victim. So the minor would be able to be the victim or the person who would be incapacitated. Now, if the minor is competent to assert their rights, then they would be a victim under the law. So a child is a victim of an armed robbery. The minor is 16 years old. That minor might well be competent to assert their rights, as well as then both parents or legal guardians or foster parents or a single adult representative would also be victims. So in that case, there could be potentially three victims who all could be asserting their rights. They could choose somebody to be their representative, but they can't choose somebody to be another victim. So just understand, with a minor, all three can be there asserting their rights, and they might all disagree about what they want to have happen. So are there any questions about that in particular? All right.
Not seeing any, Judge.
So if the person is 18 years of age or older and deceased, then the victims could be maybe the spouse or a parent or a child or a sibling of the person that is deceased. Those people would be able to choose somebody as their representative, but they cannot designate somebody else to be the victim. So the exception there, and I've noted it here, is if the victim is the defendant or a person who aided or abetted in the commission of the crime, that person cannot be a victim or a representative of a victim. So think about a case of a felony murder where somebody breaks in to a home to commit a home invasion and the homeowner kills the invader. That victim that was killed, the person that was killed, is not a victim under Marsy's law, so they cannot assert their rights. Or think in a predatory criminal sexual assault, the father of the victim is the defendant. He cannot be a victim or designate somebody to be a representative. And obviously, like, that makes a lot of sense, because if somebody is the defendant in a case and accused of committing sexual violence against a child, they shouldn't be able to say they were also a victim and say they want their rights asserted. So I just must say again that the state of Illinois did a really good job when they were looking at this and putting it into the statute to make it much more clear than just the constitutional amendment is. So this is where we really get to an issue, and it's important to understand because the Pretrial Fairness Act, when it talks about notification, references this statute in terms of the notification. So the notification requirements under the Pretrial Fairness Act include any case that's a violent crime. So violent crime under Marsy's law, under the Crime Victims Act, is any felony in which force or threat of force was used against the victim, any offense involving sexual exploitation, sexual conduct, or sexual penetration. So think most of the sex cases that we have, even if they're not a felony, any offense. So there might be a misdemeanor criminal sexual abuse that would still, though not a felony, fall under the definition of violent crime. A violation of child pornography or non-consensual dissemination of private sexual images. And I've listed the statute sites there so that you can easily see what I'm talking about. A violent crime would also be domestic battery or a violation of an order of protection, a violation of a civil no contact order, or stalking no contact order. So even if those are misdemeanors, they're still violent crimes, and therefore Marsy's law would apply to these crimes. Stalking is also included. And then also any misdemeanor that results in death or great bodily harm to the victim. And it's hard to think about what that might be, what misdemeanor might involve that death or great bodily harm, but maybe there could be a leaving the scene of an accident causing injury, something that would be a class A misdemeanor, that maybe somebody was hurt. Also involuntary manslaughter, reckless homicide, or a DUI that results in personal injury or death. Those would all apply as a violent crime under Marsy's law, meaning that all the rights that are under Marsy's law would apply to all of these people who are victims of violent crimes, which also then includes that under the Pretrial Fairness Act, these are all the people that would need to have the notification in the 24 hours before the court date. So I think that's important that we all keep that in mind, should the law go into effect as expected on January 1st.
Judge, we have a question real quick.
Sure.
I think it might apply to the slide that was right before this. It says if a person is murdered and there is no immediate obvious representative, but a friend or other person steps in, can they operate under this statute?
I don't believe so. I don't think it can be a friend because the law says family member. So I don't think a friend could just step in. Now, if the prosecutor decided that they wanted to talk to this person, but I don't believe they can assert rights as a victim.
Okay, thank you, Judge.
Thank you. Okay. All right, so personal injury. So when I was talking about like any misdemeanor that results in death or great bodily harm to the victim, or then the DUI that results in personal injury or death, it does define that. Like a personal injury would be any type A injury as indicated on the traffic accident report. So those of you who work in DUI or traffic, you might see sometimes they'll check the box that says it's a type A injury. That includes severely bleeding wounds, distorted extremities, injuries that would require somebody to be carried from the scene. So a serious injury. Also, the victim has a right to hire an attorney, and sometimes that does happen. I've had multiple cases in front of me as both a former prosecutor where the victim's attorney has asserted their rights, which is sometimes interesting, but sometimes as a judge, I've had people come to court and attorneys come to court and say that they are representing a victim. They file an appearance and then they are there asserting their rights. So a victim does have a right to hire an attorney. And it's important just, and I'll say this a couple other times throughout this presentation, the prosecutor is not the victim's attorney. And that's something that should be made very clear to the victim. The prosecutor has an obligation, and we'll talk about those, to let the judge know if the victim has asserted their rights, but the prosecutor does not have to do what the victim requests of them. They are not their attorney. The prosecutor represents the people of the state of Illinois. The prosecutor has their own ethical obligations under the law, and they may well conflict with what the victim wants. So whereas they have an obligation to say what the victim wants, they are not the victim's attorney.
Judge,
Can
we have
hire.
another,
Go ahead. Mhm.
sorry, Judge. We have another question. How would the state's attorney be informed who would be the victim representative when the victim in the case is a minor or deceased?
Well, the state's attorney's office should send Marsy's law to the letter that they send out and the assertion of rights form to whomever they know from the police department, who is the family or the closest family member of that victim. Hopefully the police have had contact with the parents or spouse or siblings or children of that person, and then they would give them the assertion of rights form, and then that person can assert their rights and have them turned in. I, as a prosecutor, did have a case where I had a victim who had no family. Her husband had severe Alzheimer's and was in care, and she had no children, no sibling, and no parents. So in that regard, I just did what I thought was the right thing to do because there was no other person or representative. Does that answer the question?
I believe so. I don't see any follow-up to that. Thank you.
All right. And then it does define, the statute does define what confer means, because the state's attorneys, the prosecutor does have an obligation to confer with the victim. That doesn't mean just, here's what's happening, here's the next court date. Confer means to consult together, to share information, compare opinions, and carry on a discussion. So it's not just a quick, here's the next court date, here's the plea, but to really confer and have a meaningful conversation. And then it does define what a witness is, which I think we all know what a witness is. It also defines court proceedings, and it's very broad what is a court proceeding and then what rights the victim has for court proceedings. A court proceeding would include if there was a preliminary hearing. It would include a post-arraignment hearing that could result in the release of the defendant from custody or alter the conditions of bond. So think again, with the Pretrial Fairness Act going into effect January 1st, 2023, as expected, that victim would have a right to be notified and to be at any court proceeding where it could result in the release of the defendant from custody or alter the conditions of bond. Now, obviously that bond is word is going to change to pretrial release, but every court date, if somebody is in custody under the Pretrial Fairness Act, the judge is going to have to look and decide if they're going to keep that person in custody or if they're going to keep the same conditions of release. And a victim would have a right to be at that court proceeding and notified about that court proceeding. A court proceeding obviously would also include a plea or a sentencing hearing, a trial, any pretrial or post-trial hearings, a sentencing hearing, a notice of appeal, any arguments before the appellate court, any hearings under the Mental Health and Developmental Disabilities Code if a person is found not guilty by reason of insanity, or any hearing related to modifying the sentence. So we're talking about probation, revocation hearings, parole hearings, post-conviction proceedings, habeas corpus proceedings, clemency proceedings. So a lot of that does not fall on our local state's attorney's office. And I'm not going to be talking a lot about what the Prisoner Review Board is supposed to be doing and what notifications are being made to victims for that. But there is a lot of notifications that are supposed to continue. So I know I'll give a positive shout out to Steve Cody, who is one of the attorneys in my courtroom, who has in the past said, you know, this victim asserted their rights and now we have a probation revocation hearing. And we need to let the victim know that. And that is true. And that's important that we continue to let victims know about that.
Judge, we have another question.
Sure.
Can the victim or a victim representative assert their rights at any time during the court case, or is it only upon receiving the victim assertion of rights paperwork?
At any time they can, but they should fill out the assertion forms. There's not a lot of case law. There hasn't been a lot of appellate decisions relating to Marsy's law. So the one thing I always wonder about in this is if a victim did not fill out the assertion of rights form, do they still have these rights? And there's nowhere in the statute that says that they don't have those rights. So I would think if a victim showed up at a sentencing hearing, even though they hadn't asserted their rights, and said, well, now I want to say my piece, a judge is going to let them do that and assert their rights at that time.
Great. Thank you.
Thank you. So the interesting thing, and I'm certain that this will change with the Pretrial Fairness Act, is that the court proceeding does not include the initial appearance. Well, we now know under the Pretrial Fairness Act that the victim has to be notified of the initial appearance, or what we are calling the detention hearing. So they would have a right to be present, but under the law as it stands now, they don't have, like for bond court, as we would call it now. They don't have a right to be present at grand jury proceedings. Obviously, those are secret proceedings, so people can't just go into there. And they don't have a right to be present at the issuance of an order or decision of an Illinois court that dismisses a charge, reverses a conviction, reduces a sentence, or releases an offender from court. That doesn't make any sense to me at all, why that is in the not included as a court proceeding, because it would seem that a case being dismissed or a conviction being reversed is something important that a victim would want to be present at. But perhaps because it is a decision of the court and not a proceeding where it's going to be a hearing or people talking, I don't really know why that's in there, but it is. It defines in the statute what sentence and sentencing is, and then it also defines what an advocate is. And I think we've come a long way in terms of making sure we're clear, and when we use the language of an advocate and the language of a victim service provider, because of course they are different. Because what an advocate and a victim discuss is privileged communication. That means it's private. So that's when we think about, like in our community, Rockford sexual assault or the Family Peace Center or remedies. Those would be programs and agencies that are providing services to victims of violent crimes. And if that person is an advocate, then those conversations are privileged. If somebody is a victim services provider who works for the prosecuting agency, those are not privileged communications. And I think we've come a long way, as I said, in that. So when the case first is brought in, the prosecuting attorney makes the initial determination of who is a victim. But in some cases, a person can come in and say, I am the victim. And the prosecutor says, no, you're not. We've chosen to deal with mom and kid, and I'm sorry, dad, we're not counting you as a victim. You've been out of the life for so long, or this is your brother, whatever it is. So the state might say they don't agree with who that is. Then it's up to the judge to decide who the victim is. I've never seen this happen here, but it could happen. So take, for example, there's a married woman. She has 2 living parents and adult children, and she's shot by her ex-husband. The woman is clearly the victim. She could choose her current husband as the second victim because that's her husband and that's who she wants to have be the other victim besides her. But maybe her parents or her adult children might want to say, well, we're victims because our mom or our child got shot and we've suffered psychological harm. And the prosecutor says, no, the criminal conduct wasn't directed against you. Then those parents or adult children could petition the court and ask the court to rule that they are the victims. So it seems to me under the law, the court should side with the prosecutor because the prosecutor has made a good argument, but that's something that the court would have to decide. If you have a defendant who's charged with harassment but not stalking, so harassment is a misdemeanor. It did not result in death or great bodily harm, so it doesn't apply to Marsey's law. So the prosecutor says they're not a victim. The person can then ask the court to rule that they are a victim because the state's attorney's office could have charged stalking, which would make them a victim under Marsey's law, but they chose not to. The court should deny that because the court looks only at the charged offenses, not what the state could have charged or what evidence could be presented to decide if any other offenses could be charged. It's up to the state's attorney's office to decide what charges to bring against somebody, and the court can't change the charges. So just think about that, prosecutors in terms of charging and things like that. Now, obviously, as a good prosecutor would probably talk to that victim anyway, but in terms of Marsey's law, they wouldn't be entitled to the notification and all the other things under Marsey's law. Let's say there's a stepdad that sexually assaults his 12-year-old stepson. The mother is non-supportive, so DCFS has custody of that 12-year-old. The stepson is clearly a victim. The prosecutor could determine that DCFS, who is the legal guardian, is also the victim. But DCFS may say, okay, we're the victim, but we're not coming to those court dates, so we're going to have the foster parent or whoever the relative that the child is placed with will be our representative. In that case, the prosecutor's responsibilities would attach to the person that DCFS as the victim would ask as their representative. So a supportive adult relative or the foster parents but not the parents who are clearly, I'm just assuming dad doesn't exist in this scenario, but not the stepdad and not the mother who is not supportive or protective of the child. In the same scenario, if you would assume that DCFS did not take protective custody of the person, but the non-supportive parents consented to the 12-year-old living with a supportive relative or friend. So they just said, that's fine. You know, Stephen can go live with Aunt Jenny. Then the prosecutor could decide, okay, the supportive aunt or friend could be the victim because that's who is taking care of that 12-year-old. So it could be complicated, but really when you get to the heart of it as the prosecutor or the victim services provider or the advocate, and you're working with this family, you'll know who's the one taking care, who are the people that are really involved. And hopefully there's not a big conflict in the family between parents and adult siblings and the victim or the victim's spouse as to who is the victim. Hopefully they're all supportive of each other. So again, going back to defining who is a victim, if a woman is a victim of stalking and a violation of order of protection by her husband, he cannot claim to be the victim, even though she's allowed to have a second person because he's also the defendant. And if the victim is murdered by her husband, he cannot come in and assert rights as a victim, saying that his wife was murdered and therefore he's a victim if he's the defendant. So I just want to make sure that that's clear. So then there's a whole list of responsibilities that a prosecutor has and must do. And these are difficult, especially a lot of the notifications are difficult. So it can be the prosecutor or the prosecutor's staff. And I will say in some of the states where Marsey's law was originally passed, and then now I think it was in South Dakota, where it was originally passed and then repealed, it was because the prosecutor's offices felt it was overwhelming to do the notifications that they're required to do under Marsey's law, that it was too expensive and time consuming to be able to have that done. Because a prosecutor or their staff is supposed to give notifications upon the filing of an information, the return of an indictment, or the filing of a petition, a delinquency petition in juvenile court. They also are supposed to say, okay, here's the date, time, place of the proceedings, if sometimes things change. So look at us right now. We had a fire in the main courthouse, and now we're trying to adjust and moving court dates around. And some judges, myself included, are moving court dates up or back. And that becomes a real burden, especially when the prosecutor right now can't be in their offices to be able to contact the victim and let them know that the court date has changed or let them know everything that's going on. So the victim also has a right to know about the ultimate disposition of the case, if there's an appeal that was filed, and any request for post-conviction review. Now, we know often in domestic violence cases and that it can be difficult to locate the victim. And that's often a conversation that we're having. Maybe they moved because they feel unsafe. Maybe their phone is turned off. Maybe they're afraid to be seen as working with the prosecution. So they can be really difficult to locate. The state and the prosecutor still must attempt to make this required contact. But it's important to bear in mind, and we do this a lot with the phone OPs, is make sure that you know there could be ramifications for that victim of you making contact. So phone calls might be being monitored, or text messages or mail that's going to the house might be something that is problematic for the victim. Maybe email is a safer way. Maybe contacting through an advocate is a better way to handle it. So that's just some thoughts to put out there, because obviously notification is important, but when we're talking about domestic violence, notification can be dangerous. So that's something that needs to be thought about. So here are some of the other responsibilities of the prosecutor's office. They need to make sure that victims are getting their property back that's held by law enforcement. Now, sometimes things have evidentiary value and that victim might never get it back. I know, oddly, oftentimes when I did sexual assault cases back as a prosecutor, victims really wanted their clothes back from the sexual assault. And that was really hard to explain to them that they weren't perhaps going to get it back. But the prosecutor should be really looking at what can be returned to the victim, to let the victim know of the different programs to be able to get them restitution, or through the Attorney General's office to maybe get them some money. The prosecution should be making reasonable efforts to consult with the victim before making an offer on the case even. And I know in my courtroom, I feel like my prosecutors do a really good job with that. Oftentimes, a defense attorney will say, here's this, and the prosecutor might want to take that counter offer right then and there, but they're very good about saying, I need another court date, judge, because I need to consult with the victim on this case. And judges should be understanding of that. As much as we want to move our calls quickly and efficiently, it is very good. Also, the victim has a right to make a victim impact statement prior to entering the plea agreement. So I've certainly had that at a plea where the victim makes a statement before I would accept the plea. They have a right to speak about it. Now, a victim does not have a right to veto a plea or a plea agreement or say, I want a trial, no deal. They have a right to say that, but that's not their right. Again, the state's attorney's office and prosecutors have substantial power in making those decisions. So whereas a victim has a right to be consulted and should be able to express their opinion, they don't have a right to veto a plea agreement or assist on a trial. And as many of you might expect, and it comes as no surprise, there may often be cases where I'm doing a sentencing hearing where the victim comes in and speaks on behalf of the defendant who has pled guilty, or comes in and wants to tell me that none of what the defendant pled guilty to happened. That's their right to do so. So just because somebody's not saying what the prosecutor wants them to say or what the prosecutor believes is true, that doesn't mean the victim doesn't have a right to speak. But again, that comes up with the issue of the prosecutor is not the victim's attorney. And if there is a victim that has asserted their rights, or a victim that is coming to court and consulting with the prosecutor, I think it is really incumbent upon the prosecutor to make it clear to them, I don't represent you. I will consult with you. I will tell you everything. But if you feel that you want an attorney to come in and represent you, you can hire an attorney. But again, prosecutors have very strong ethical obligations that they have to follow.
I have a question.
Go ahead.
Is notice defined? How would a state's attorney know if they have satisfied notice?
It's not defined. And that's what's really difficult. And that's what's really difficult on the Pretrial Fairness Act. So what I think is that the state's attorney's office should keep a good log in their file, whether it's the victim services provider that sent out the letter, and to make note, I sent this letter on this date and I mailed it to this address. I sent an email on this date to this address, and keep a copy of the email. I made a phone call and make a log of the phone call, just so that if it comes up later where the victim says, well, I wasn't notified, and they try to come to the judge and want to have different things undone, which they can't really do, but if they want to make an issue of it, at least then the prosecutor can say, judge, here's all the efforts I made. Just how we see public defenders and defense attorneys all the time, whose clients say, well, my lawyer never came to meet with me. Oftentimes those lawyers will come into court and say, here's all the times I've met with my client, or here's all the times I've attempted to meet with my client. So I think it's that notice that the state's attorney needs to do. I mean, I've recently kind of come around to thinking email is a good way, because I think it's private to people, and most people don't change their email addresses. They might change their address or their phone number, but a lot of email addresses are like lifelong that people have, and then there's a paper trail. But no, it doesn't really define notice, except that they should attempt to do it and keep a good record of it.
Okay, thank you.
So if there's a case where the victim has asserted their rights and the judge says, oh, this is an assertion of rights case, state, have you consulted with the victim prior to making the offer or entering into the plea? And the victim said, or the prosecutor's like, no, I need time to do that. The judge should give you time. Because the prosecutor must notify the victim of the offer and negotiations within 2 business days and confer with the victim. And remember, confer isn't just, here's the offer, they're going to take it. Conferring is an actual conversation where you are explaining to the victim, here's the sentencing range, here's what they can get, here's what they offered, here's why I'm making the offer that I am, like to have an actual conversation. It also would then be a way for, if the victim wants to be present, that they have time to contact their work or make childcare arrangements or get support people in place so that they can be in court as well. So a judge should be understanding of that. If you say, my victim couldn't be here today, but she wants to be here for the plea agreement, can we get another date? The judge should allow that. And then also, just as the judge is under the obligation when I speak to defendants in court to explain things clearly, the prosecutor is under that obligation when they meet with the victim. So not just to say, yeah, his extended term, MSR is 4 years, da, 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 da. People don't know what that means. So to explain things, and that's one of the rights that's listed, to explain things in non-technical language in all the details of a plea, a verdict, or an adjudication. And that's really important. And I think when we talk about procedural fairness, which is something that is very important with the judiciary, that applies to everybody else as well, to really explain things as clearly as possible, because then people feel that they know what's going on. And even if they don't agree with the decision, at least they understand it and they've had an opportunity to be heard. So I do think that's important. So think about, and this does happen, it just happened at a sentencing hearing in front of me recently. The survivor has a right to make a statement and be present and is the same as the defendant. So even if the statement is contrary to what the prosecutor wants to hear. So at the sentencing hearing I did on Monday, the victim stood up and said none of the things happened and it was a misunderstanding. And the prosecutor, again, Steve Cody, was excellent in explaining to her what we were doing. We took time for him to do that, and then allowing her to say what she wanted to say. And that's what really the thrust of Marsy's law is that a victim or survivor gets to be heard. So again, make sure you're talking to the victim like a person, you're explaining everything in a clear, non-legal way. So a lot of these things are just responsibilities that prosecutors continue to have. There should be a secure waiting area during court proceedings so that they don't have to be close to the defendants. So if you know as a prosecutor that, oh, my victim's going to be here, make sure you're letting the bailiff know. Make sure that we are making sure that they're separated, that the bailiff can even stand in an area so that they're more on top of things. Especially when things are more hotly contested or there's a lot of emotions involved. So make sure that if you're going to meet with them, we have these conference rooms where you can meet with people. Judges can hold back the defendant and the defendant's people so that the victim and the victim's people can leave first, or if the prosecutor wants to meet with the victim, then we can send out the defendant's family and people first. So that's just a really important communication between the prosecutor and the court and the bailiff to make sure that everybody is safe. And if you do think that there's going to be an issue, you can always ask the court or ask for extra security to be brought up. It's also important to explain to the victim what a sentencing hearing is, what the minimum and maximum amount of time, what the judge is going to be looking at, talking to them about the different factors and aggravation and mitigation so that they understand what's happening, just the same as the defense attorney would be explaining to their client, hopefully. That they need to be asking for, you need to be asking for restitution. And then if the person goes to the Department of Corrections, that the statement, if there is a victim impact statement, that needs to be sent to the Prisoner Review Board so that they can look at that when the person comes up. And under the Safety Act, the Prisoner Review Board has taken a bigger role in terms of how long somebody might be in custody, how long somebody might be on mandatory supervised release. So it is important that the Prisoner Review has that. It's also important, and under Marsy's law, and I have the statute listed there where it says that the prosecutor's office or the staff of the prosecutor's office are telling victims about services and assistance that are provided by other agencies. Because obviously a prosecutor's office can't do all the counseling and meet all the needs that a victim may have. I mean, one of the great things about the Winnebago County State's Attorney's Office is the Homicide Survivors Support Group. And so that's a really good thing that they can be referring people to, as a place that they can go and talk to other people that have lost loved ones from a violent death. But also you should be telling them, you know, we're really lucky in our community. We have remedies. We have the Family Peace Center. We have Rockford Sexual Assault. so that there are programs and counselors available to you to pass on that additional support and information is important, and it's one of the rights that is required under Marsy's law for prosecutors to be doing that. So again, make sure they're aware. They can get an order of protection. Make sure you're talking to them. You can go talk here about safety planning. You can talk about counseling. It's really important that a survivor of domestic violence or a survivor of child abuse or stalking or sexual violence, that they're passed on, that there's a showing to them that there's support for them and that they don't have to go through this alone. Also referring them to the Attorney General's program that can help them with to pay for financial loss that they got as a result of the crime. So there's an assertion of rights form. The Attorney General's office has this prepared form, and it's just a form, and then it has a bunch of check boxes, and then the victim can just go through and decide what rights that they want to have. And I thought everybody would just assert every right, but that is not the case. Sometimes they just check the right that they want to be notified of a court proceeding. That's fine, and that's all the state's attorney has to do. But the victim can revise that form at any time. And then it should be the judge should, and I'm not really going in this presentation about everything that the judge is supposed to do. That's a different presentation I've done, but the judge should be looking at the file, so the docket entries on FCE, and seeing if it's an assertion of rights case. And I do that, and then I write like VAR on my docket. So I try to remember at every court date to say, this is a case in which the victim has asserted their rights. I have reviewed the assertion form. My attorneys are very good at bringing it up to me if I forget to do that. And then I can ask the attorney, have you had the necessary contact with that? So those get filed, but then the state is also giving a copy to the defense attorney and a copy for their own file. And again, a victim can retain an attorney, and that attorney needs to file an entry of appearance limited to asserting the victim's rights. And then upon filing of that entry of appearance and service to the state and the defense, the victim's attorney can receive copies of notices, motions, and court orders in the case. So also when we're talking about sexual assault cases or child victim cases, there could be cases that we have in court where somebody is charged by initial or Jane Doe or John Doe. The victim is named that way to try to protect their identity. That is fine on the assertion of rights form to put that as well. They don't have to disclose their identities or names just because they are asserting their rights. That can still be private. So they can file it under their initials or John Doe, Jane Doe, whatever it is. So that can be in the court file. The prosecutor can also assign the form on behalf of the victim and keep the signed form from the victim in the file, if the victim in the state's attorney file, if the victim wants to keep that private. If the defense objects, then the court would make that decision. But as we see here in the statute, the victim has a constitutional and statutory right to be treated with fairness and respect for their dignity and privacy. So that's important. Now there are responsibilities that victims have. And if they don't do this, then there's different ramifications for the victims. But they have the responsibility under the law to timely report the crime, cooperate with authorities throughout the investigation, prosecution, and trial, to testify and notify of any change of address. They have the responsibility to notify of a change in contact information. I know this does not often happen. If the victim doesn't do that, the court can find that the victim's failure constitutes a waiver of a right. So they waive their right to notification if the prosecutor can't find them to notify them. They need to be informed of their responsibilities. They need to send in the written notice, the prosecutor's office does, and then the victim checks the rights they want to have. So I did already talk about this, but if the victim has asserted their rights, the judge needs to ask the prosecutor whether they were given written notice of or given notice of the next court date or what the plea is. If the court finds that timely notice was not made or that the victim was not adequately informed, the court cannot rule on any substantive issue, accept a plea, or impose a sentence. So that's really important, that the state is making the notifications that they can. So now here's another interesting part in motions to exclude witnesses. A motion to exclude the victim from any part of the trial must be filed at least 60 days prior to the date set for trial. That's not actually realistic because a lot of judges are not setting trials out 60 days. So it would be really difficult for the defense to file a motion to exclude at least 60 days prior. But the motion must then state with specificity the reason why exclusion is necessary to protect a constitutional right of the defendant, and then must also contain an offer of proof. And then the court must rule on that within 30 days, so that then in theory, the victim would have a right to appeal that decision. So victims of domestic violence, stalking, sexual violence have a right to be in court the same as the defendant does, the victim of any violent crime. They also, the statute says that advocates and support people have a right to be present. So sometimes you might see that maybe the survivor made a statement to the victim services provider relating to the crime. If that survivor wants that support person, the victim services provider, to be present in court, then that is something to be litigated in front of the judge, where the defense is going to have to state with specificity and with an offer of proof as to why the testimony of that witness would be altered by them being able to be in court. In my practice as a prosecutor and as a judge, most of the time, the defense attorneys have no issue with the victim being able to be in court, because obviously what they say happens is not going to be materially altered by them seeing what other people have to say. But this is something, even if the timeframes aren't going to always work because of how quickly cases may be set for trial, it is something that should be brought up to the judge and then litigated in front of the judge. Then the court must state when any time the court has a number of responsibilities. I'm not going to go through all of them, but I do want to make sure that you understand what they are so that you can then remind the judge in a respectful way what their responsibilities are if they're not doing that. So the court must state the reasons on the record if the court decides to deny a request made by the prosecutor, victim, or the victim's attorney. So if the victim wants contact, which does happen, then the court should say on the record why they're denying the reasons for contact. The court must not only state why a continuance is being granted over a victim's opposition, but also what procedures will be taken to avoid further delays. So if a victim comes in and they've asserted their rights and they want this trial right now, I want this trial set in 2 weeks, and then the state comes in and they want a continuance, or the defense does, and the court is granting it over the victim's objection. So I definitely have had that happen when I was a prosecutor, where a victim does not want a continuance, and then I've had to put on the record why, as the prosecutor on the case, I needed to make the motion to continue over their objection. And then the court must state why they're granting it and how we're going to make sure it's not further delays. If the court excludes a victim from any part of the trial, the court must state on the record the facts supporting the finding that the victim's trial testimony would be materially affected if the victim hears the trial testimony of other witnesses. A victim or victim's attorney can't assert a right or seek a remedy when either the prosecutor declines to do so or the court denies the prosecutor's assertion or request. So the victim or the victim's attorney can file a request within 10 days of the court ruling. It's not a request for a reconsideration. It's just them wanting to assert their right to seek a remedy. So it's kind of complicated. I don't think this happens very often. And again, there's not really a lot of case law on Marsy's law at all. So for example, if a victim has asserted a right to notice of court proceedings and a right to be heard, and they have a right to notice then of the plea. If at a status date, the defendant says he wants to take a plea, The prosecutor should object because the victim was told that the court proceeding was a status date and not a plea. The prosecutor should request a hearing to be scheduled at least several days out so that the victim can be notified and arranged to be able to attend and be heard. It's a lot easier now, I think, with Zoom, but the statute also says that this delay should not be attributable to the people. I mean, I think that that would be the case if, since the defendant is not demanding a trial and wants to negotiate and to try to have the plea, that would hold the time. But that's, to me, a dangerous area as a prosecutor. The prosecutor is the one to assert the rights of the victim unless the victim has hired an attorney. So if a defense wants the victim's counseling records, the prosecutor would be the one filing a written opposition if that's what the victim wants, unless the victim has an attorney. Now, it could be that the state also wants those counseling records, but it would still be up to the state to assert the right and tell the court the victim does not want their counseling records to be turned over, but we and the defense attorney think they should be turned over, and here's why. But the state is still making sure the judge knows that the victim has asserted that right and don't want that turned over. Another thing that's interesting is victims have a right to communicate with the prosecution before charges are filed. So let's say there's a homicide or a sexual assault case, and the state is waiting for information or DNA results before they charge the case. Or often in the child victim cases, the state may be wanting more follow-up by the police officers to look for something to back up what the victim said. They have a right to, the victim has a right to consult with the prosecutor that's reviewing the charges before charges are filed. And then I think, again, that goes a lot with procedural fairness, just for them to be able to understand what's going on. That does not mean that the victim decides what the charges are or that there are no charges, but just that the prosecutor must communicate if they want to. The Attorney General's office does suggest that an advocate on a case that is not yet charged contact the victim on a weekly basis to keep them notified. I don't know how realistic that is, but that's a suggestion by the Attorney General's office. They also have a right to communicate with the prosecution after charges are filed, and we've discussed that a lot. A victim cannot, again, veto a plea agreement, demand a case go to trial, intrude upon a prosecuting attorney's strategy, or usurp prosecutorial discretion. Just because they have a right to consult with the prosecutor does not mean that they are in charge, and that can become difficult in some scenarios, in some cases, where maybe the victim wants a maximum sentence, but the prosecutor doesn't think that's appropriate, or the prosecutor wants a maximum sentence and the victim doesn't think it's appropriate. It's important that the prosecutor, again, assert those rights and tell the court what the victim thinks, but that doesn't alter what the prosecutor has to do. Nothing in the act should be construed to alter the powers, duties, and responsibilities of the prosecuting attorney. And I think that's important to understand. Again, continuances I've talked about plea agreements and court proceedings. So you'll have all this as something that you can have. The last thing I kind of want to touch on as I wrap up are private counseling and medical records of a victim. I've written here domestic violence and sexual violence. But those records are privileged. Medical records are privileged. And if a victim has asserted their rights, there's certain steps that have to be followed under Marsy's law. The victim has a right to notice in a hearing before disclosure of confidential or privileged information or records. So the defense attorney, if they're the ones seeking it. So sometimes defense attorneys want a victim's counseling records to try to show they're untrustworthy or that they have a addiction or something like that. The defense attorney must file a written notice, a written motion before the subpoena may be issued. It must contain an offer of proof regarding why those materials are relevant, admissible, and material, and they must give notice to the victim. The burden is on the defense to prove by a preponderance that the records are not protected by an absolute privilege and the records contain relevant, admissible, and material evidence not available through other witnesses or evidence. That's pretty hard to do if the defense doesn't know what's in the records, but that's what the statute calls for. Oops, sorry, I keep bouncing back and forth here. If the defendant meets the burden on both prongs, then the court would issue, on the prongs there, the court would issue a subpoena, and then that would be reviewed to the court, returned to the court for an in-camera review. And then the court would have to say due process requires part or all of the records to be disclosed. And then the court would provide the portions that they're going to disclose to the prosecutor and the victim, not to the defense at that time. And then they would have 30 days to seek appellate review. I do not know of any case where this has ever happened, but that is a right to appeal that a victim would have, trying to keep their records private. Just because the prosecutor has copies from the court does not mean the copies at that point are subject to the rules of discovery, and that's in the statute as well. If a prosecutor wants to subpoena privileged or confidential testimony or records, they must first file a written request with the victim, or a written request for consent from the victim. If the victim does not consent, then they must serve a subpoena at least 21 days prior to the date a response or appearance is required to allow the subject to file a motion to quash or to request a hearing. They must also send written notice to the victim at least 21 days prior to the response date to allow the victim time to file a motion or request a hearing. The question here being is, do these rights attach even when the victim doesn't assert their rights? And we have that often in court, where the victim has not filled out an assertion form, but they don't want their records returned. So they might come into court. So I'm always going to let that victim say what they want to do, whether or not they have asserted their rights formally or not, because they may not want their medical records turned over. So again, they do have the right to have an advocate and support person present at all court proceedings. They have a right to access the pre-sentence investigation report. There are different things that the prosecutor has to redact, but make sure that you understand they do have a right to have that and review that. And then the prosecutor is supposed to tell the victim to maintain confidentiality. That's a real difficult one, because of course I can envision cases in which a victim, wants to pass out copies of certain things that are in a pre-sentence report. So it must be redacted. That I don't know of any cases where victims really ask for the pre-sentence investigation report. They also have a right to HIV and STD testing to be done. And remember, that's an important right in any sexual violence case, that the prosecutor should be asking for that and can be asking for it well before a conviction has entered. So if you don't hear from the victim, a victim could have waived or forfeited their rights by their own inaction, but it is essential to keep a clear and accurate record of all contacts and attempted contacts. And I did talk about that earlier. A victim cannot, or a prosecutor cannot waive a victim's right, but should inform the court if the court is saying, well, have you had contact with this victim before a plea? No, but here's all the attempts that I've had.
Judge, we have a question about medical record subpoenas.
Okay.
Is a subpoena served on the victim to appear in court, or a copy of the subpoena for records with notice?
So how it's been working is they don't have to be subpoenaed to court, because they don't have to come to court if they don't want to, but the state will send them like a certified letter or something to prove that there was an attempt at notice of what the court date is going to be. So often the state will ask me for a date, a month in advance, so that they have time to give notice to the victim of what that court date is, so that they can come in and they're told, but they're not subpoenaed for that court date. They're not forced to be there if they don't want to.
Thank you.
Okay. And then the real question is then, what if the victim's rights are violated? What's the remedy? Well, you can't really take away any of the defendant's rights. And anytime that there's a butting of heads between a defendant's right and the victim's right, it's the defendant's rights that's going to come back. So under like a bond motion, how we have it under the law today, if the court found that there was a violation, that the state did not inform the victim of the bond motion, then the court would just redo a new bond motion. It wouldn't be a motion to reconsider, it would be a new bond motion. Would that really change necessarily the court's ruling? I don't know. The court can't vacate a conviction because a victim wasn't told about it. They can't order a new trial. it does allow for appellate relief. But I haven't seen really, as I keep saying, many cases where that has happened. So that's all. Are there any questions?
Feel free to go ahead and unmute yourself if you have any questions as we finish up here.
Okay, I think Nikki's going to send out copies of this so that you can have different sites and things that you want. This is a really ever-changing area in the law, and I think it's really going to be essential in 2023 with the notification requirements under the Pretrial Fairness Act, that there are good documentation and records kept about the attempts to get in touch with victims and survivors and let them know what their rights are.
Thank you, Judge Clifford. I did drop the slides in the chat as Judge Clifford was presenting. I will send those out along with the evaluation link again. I know there's a few of you that are watching as teams or sent on information to your coworkers. Because of that, I may not have the email on file, so just pass those emails on to people that you know were here today and may benefit from that information. We also recorded today's Lunch and Learn too, and we're happy to provide that recording. So this is a whole bunch of good information. Thank you, Judge. Any last questions before we get going?
Just want to thank Judge Clifford, very thorough, and is impressive. You know, where I used to sit in criminal court, all that she was saying just came back to me. To refresh my recollection, she was right on point for many of those, sections of the statute that apply, and even had some good anecdotal things. So well done, Judge Clifford. Thank you.
Yeah.
Thank you, Chief. I really appreciate that. Thank you very much. Thanks for your help, Nikki.
I did have a quick question. Effective January 1st, victims of violent crimes have a right to notice of the bond hearing and also to be present
Right.
at the bond hearing.
Except I guess it's a detention hearing, not a bond hearing, but yes.
Thank you.
I'm just trying to learn the new lingo, that's all.
Yes, me too. Thank you very much.
Right. So we have to kind of do an about face. We won't talk about bond anymore. There'll be detention / conditions of release hearing, and the victims domestic violence also have the right to request a criminal OP, Judge Clifford, right?
Right. A victim has a right to get an order of protection, criminal order of protection at the time of the detention hearing or any time thereafter. That's a whole nother long presentation I could do another time on how to do that. But yes, that's true, Judge.
All right. Well, thank you everybody so much for taking your lunch hour and spending it with us and giving us a few extra minutes of it as well. I hope you all have a good rest of the day and rest of your week. And thank you again.
Yeah, thank you to everybody that came. I really appreciate it. Thank you.
Bye, everybody.
Thank you.